Welcome back to the PI show. Before the break, we were talking about the case of Mr. McKinnon, who he's a 62-year-old rigger who was the subject of litigation in the Court of Appeal. And I think the judge quite helpfully set out the things which judges should take into account when they look at pain and suffering consequences of a serious injury. First thing he says, quite rightly, I think, is the judge should look out for what does a plaintiff say about his pain, both in court and
what he does about it,
and to the doctors. Yes. Secondly, what he actually does about it, treatment and medication.
Yes.
Thirdly, what do the doctors say about the extent of pain and suffering? And you'd want to highlight the treating doctors.
Yes. Yes.
Because medico-legal people just see the person once over a period of 5 years.
Yep.
A GP might see a person once a month.
That's correct.
So the GP is pretty important.
I think so. And lastly, the objective evidence, what it shows about the disabling effect of pain. So you'd introduce people that know you. You know, you'd probably want to get fellow workers or members of the family to swear an affidavit to say, Mr. McKinnon was like this before and he's like this after.
Yeah.
And that's pretty significant.
But objective evidence, on the contrary, can be video surveillance.
Yeah, it can be.
Which can show people doing things inconsistent with their
Albeit
injuries.
the thing with video surveillance, Harry, is you only get a snippet. And if there's anything that may assist the plaintiff, you can bet your bottom dollar it gets cut out. Yeah.
There can be 24 hours of video surveillance, and in court they show, well, even less.
That's right.
Out of 24 hours.
That's correct.
So, but as I say, I think it's a helpful decision for lawyers in this area.
I think it's good for injured people, that's for sure.
Yeah. Now,
I'd be on the issue of surveillance. I'd be a lot happier if they weren't allowed to edit the tapes. I'd be happier if they took 24 hours of film, showed a whole 24 hours.
Well,
I know it'd take forever to look at, or just fast forward or whatever.
Yeah, no, they can't show 24 hours, but they can at least disclose to a court that they've taken 24 hours.
And give it to the plaintiff, and the plaintiff and his lawyers can look at it in their own time.
Yep. No, I agree with that.
And that'd be a lot fairer than what we've currently got. But Harry, getting on to these recent amendments of legislation, I mean, we might as well just go through the key elements.
Well, the background is that the Victorian government looked at amending the Accident Compensation Act. They had an inquiry run by a prominent QC, Mr. Hanks.
Yes.
And Mr. Hanks delivered a report, I think, last year. And on the basis of that report, they've tabled amendments to the Accident Compensation Act. It affects every person who works in Victoria. And it's amendments to an act which first started in 1985. You probably remember.
I was around when it started. It was the 1st of September 1985. I
yeah, and I think there was a party to celebrate its 25th year.
There was
by a number of barristers and lawyers.
That's in fact correct.
And so the act started off fairly thin.
And it's changed so many times, and
it's been amended over the years, and it's quite a complicated act.
It is. But what they've done here, Harry, is they've improved some of the benefits available to the injured workers. And, you know, some of the things they've changed is, for example, the no-fault psychiatric benefits. Let's say you got 30%. What's that gone up by? It's, you know, originally 30% only gave the worker $13,000, and now it's gone up to about $68,000. That's a pretty significant increase.
Yeah.
Weekly payments. After your first 13 weeks, it used to come down to 75%. Now it's at 80%. It's not much, but it makes a difference.
Yeah.
You know, other things like superannuation. Previously, you could never claim it.
And it wasn't paid on your behalf.
That's right. And if you've been on payments for more than 52 weeks, you're entitled. Overtime and shift allowances. What happened there?
Well, that's been increased from 26 weeks, from 6 months to 12 months. So
which helps again.
Yeah, you can get weekly payments which include your overtime and shift allowances for now 12 months instead of 6 months.
And one of the biggest increases has been the amount of compensation paid. It's gone up from $1,300 to $1,760, which is a pretty good leap.
But that's the maximum you can claim.
That's correct.
So you claim workers now would claim 80% of their pre-injury average weekly earnings, up to a maximum of $1,760,
which helps those that were on high incomes.
Yep.
And also the penalty claims have gone up significantly.
Very significantly. I think they've almost doubled, Tony.
Well, 273 to 503, so that's very, very high. They've increased they've introduced penalties for discrimination of workers, injured workers, which is another interesting.
Yeah. So if an employer sacks someone because they've made a claim, then the employee can be prosecuted. But look, I think it's what's called all the no-fault benefits have been, some have been improved significantly. The common law part of the Accident Compensation Act hasn't really been modified.
Basically the same.
They've modified a few provisions that have eliminated some unfairness to the workers.
But Harry, what I like is this one, that a conciliator can now make a determination that an employer pay or WorkCover pay the worker up to $5,000 of medical and like expenses. Just saves a lot of mucking about and time, because there was a lot of disputes involving medical and like expenses.
That is typically things like physiotherapy treatments.
Yes.
And they can order that the WorkCover Authority pay up to $5,000 for ongoing medical treatment.
If you're working and have to go to conciliation, they'll have to pay your time in conciliation, which once upon a time they wouldn't pay it.
No, that's
time lost.
The transport costs. If you take a day off and have to attend conciliation, WorkCover will pay for that. I think that's a fair.
Yeah, I think so.
Amendment. But look, it's an ongoing saga because the Act tries to give people no fault benefits, and then in my view, it has improved some of those.
Yeah, but one of the backward steps is the definition of suitable employment. What they've now done is they've introduced a provision that says that suitable employment means that even if a particular job that's been suggested is not available in the marketplace, it's still suitable employment. That's a backward step, if you ask me.
And it's a backward step because it stops people's weekly payments after 2.5 years. So if you can go back to a suitable employment, and I think I've seen cases where they've said a petrol pump attendant, and I think in Victoria there are 3.
Yeah, and
now,
so they're
that's suitable employment.
That's right. They could identify 2,000 people and no one gets a job.
Yeah.
But Harry, we've got to go to a sponsors break. So, and also after the break, we've got Viv's mailbag, which is being handled by Beth in her absence while she's on maternity leave. So stay tuned, viewers. We'll be back very shortly. Thank you.